Mechanics and materialmen's liens are liens granted by the Constitution and the statutes of the state of Texas to contractors who work on real estate. So if they build a new house, if they build a building, if they repair a building, or if they add to a building, any of that sort of work would result in a lien against the real estate in favor of the contractor. They then are granted a clout on the title to the property so that the owner then has difficulty in selling the property to a third party if the lien hasn't been cleared up. The restrictions on enforcement can be difficult for the mechanic or the materialman, which requires that they file an affidavit with the county property records within a certain number of months after the completion of the work, and the failure to either file the affidavit in a timely manner or the failure to file suit within the time prescribed can mean that the lien is not enforceable. If, say, a bank holds a mortgage on a piece of property, and after the mortgage is recorded, additional repairs or improvements are made to the property and the person performing that work isn't paid, and they perfect their lien with all the appropriate timeliness, then with regard to their lien, they take priority over the bank as to the lien on the property. Once the bank has foreclosed and sold the property at auction, the party buying the property at auction could even be liable to the contractor for their attorney's fees in enforcing the materialman's lien, which I believe is surprising in that the person who buys the property at auction didn't contract with that contractor in the first place. They're just buying a property at public auction, and so for them to have walked into an attorney's fees claim can be a substantial burden to them.